Hi, this is Lee from the Law School Toolbox and the Bar Exam Toolbox. Welcome back to another episode of Substantive Spotlight, where today we're diving into the exciting world of civil procedure. We're about to tackle one of the most fundamental concepts in litigation, jurisdiction. Think of it as the VIP pass that lets courts hear your case. Without it, you're not even going to get in the door. You know what's fascinating about jurisdiction? It's everywhere in our legal system, quietly determining which disputes get heard where. Whether you're suing your neighbor over a fence dispute or taking on a multinational corporation, jurisdiction is the invisible force field that maps out where these legal battles can take place. Today, we're breaking down the key concepts we've covered in our Listen and Learn series, and trust me, mastering these will make your civil procedure, professor, or bar examiner do a double take. Let's start with the big picture. Jurisdiction comes in two main flavors: subject matter jurisdiction, which kind of cases a court can hear, and personal jurisdiction, which people or corporations or organizations a court can exercise authority over. Think of subject matter jurisdiction as a restaurant menu. It defines what the kitchen is prepared to serve up. Personal jurisdiction? That's more like the restaurant's delivery radius. It determines who they can reach. First up, let's look at subject matter jurisdiction. Federal courts are courts of limited jurisdiction. They can only hear cases that fall into specific categories, like being a specialist doctor who only treats certain conditions. There are two main paths into federal court: federal question jurisdiction and diversity jurisdiction. Federal question is straightforward. Your case must arise under federal law, the U.S. Constitution, or federal treaties. It's the express lane for cases like patent disputes, civil rights violations, or federal crimes. Diversity jurisdiction is where things get spicy. Here, we're looking at cases between citizens of different states where the amount in controversy exceeds $75,000. But wait, there's a catch. We need complete diversity, meaning no plaintiff can be a citizen of the same state as any defendant. It's like planning a dinner party where no guest can be from the same hometown as the host. So let's break this down with a quick example. Paula from Pennsylvania sues Derek from Delaware and Connie from California for $100,000. Is there complete diversity? Well, yes. No plaintiff shares citizenship with any defendant. But what if Connie was actually from Pennsylvania like Paula? Game over for diversity jurisdiction. Even one shared state of citizenship kills complete diversity. And don't forget about the amount in controversy requirement: more than $75,000, excluding interest and attorney's fees. The courts want to make sure the case is substantial enough to warrant federal court attention. It's like a minimum purchase requirement for free shipping. You've got to meet the threshold. Now, sometimes a case has claims that would qualify for federal jurisdiction hitched to claims that wouldn't qualify on their own. Enter supplemental jurisdiction, the +1 invitation of federal court. If the claims are part of the same case or controversy, think same nucleus of operative fact, the court can exercise supplemental jurisdiction over the related claims. But be careful. In diversity cases, supplemental jurisdiction has some important limitations to prevent plaintiffs from gaming the system. Moving on to personal jurisdiction, or the long arm of the law. The question here is, can this court exercise authority over this particular defendant? The analysis differs depending on whether we're dealing with a traditional basis or a long arm statute. Traditional bases are straightforward: domicile, where you permanently reside; presence, being physically served with process in the forum state; or consent, agreeing to the court's jurisdiction. These are like the 3 guaranteed ways to get someone to your party: invite a roommate, hand deliver an invitation to someone you bump into, or get someone to RSVP yes. But what about defendants who aren't from the forum state? That's where long-arm statutes come in, allowing courts to reach defendants with certain connections to the state. The key here is the minimum contacts test from International Shoe. Does the defendant have such minimum contacts with the forum state that exercising jurisdiction wouldn't offend traditional notions of fair play and substantial justice? This analysis breaks down into general and specific jurisdiction. General jurisdiction is for defendants who are essentially at home in the forum state. Think corporations incorporated there or with their principal place of business there. It's like having an open invitation to your neighbor's house. They can invite you over for any reason. Specific jurisdiction requires a connection between your forum state contacts and the underlying claims. Did you purposefully avail yourself of the benefits of doing business in the state? Was it foreseeable that you could be hailed into court there? Would exercising jurisdiction be fair? These questions form the backbone of the specific jurisdiction analysis. Remember, a court can have subject matter jurisdiction but lack personal jurisdiction, or vice versa. You need both to proceed. It's like needing both a ticket and an ID to board a flight. Missing either one means you're not taking off. Now, even if you've cleared the jurisdiction hurdles, you still need proper venue, the specific place where your lawsuit should proceed. Think of jurisdiction as getting into the right courthouse, while venue determines which courtroom inside the building you'll be in. Venue is proper in a federal district where any defendant resides, if all defendants reside in the same state, where a substantial part of the events giving rise to the claim occurred, or, if there's no other district available, wherever the defendant is subject to personal jurisdiction. It's about convenience and the fairness to the parties involved. And here's where things get interesting. Even if venue is technically proper, a defendant might move for the transfer under the doctrine of forum nonconvenience if they believe another venue would be more convenient for parties and witnesses. The court will balance factors like witness locations, access to evidence, and local interests in determining whether to transfer the case. All right, let's get tactical. When approaching jurisdiction issues on an exam, here's your battle plan or attack plan. Number 1, start with subject matter jurisdiction. Is there a federal question? Is there diversity jurisdiction, complete diversity plus that amount in controversy? Could supplemental jurisdiction apply in related claims? Number 2, then analyze personal jurisdiction. Are there any traditional bases like domicile, presence, and consent? If using a long-arm statute, what does the state statute permit? Does the defendant have minimum contacts with the forum state? Is jurisdiction general or specific? And would exercising jurisdiction be fair and reasonable? And 3, finally, check venue. Is venue proper under the statute? Any reasons why transfer might be appropriate? Remember, jurisdiction and venue questions often come loaded with red herrings and tricky fact patterns. Be methodical and don't get thrown off by irrelevant details. For a deeper dive into these topics, check out our Listen and Learn episodes on subject matter jurisdiction, personal jurisdiction, and venue. Don't worry, we will include links to them in the show notes. Episode 92 breaks down diversity and federal question jurisdiction, while episode 169 gives you everything you need to know about personal jurisdiction. For venue issues, episode 180 is your go-to resource. This is Lee Burgess, signing off from Substantive Spotlight on Civil Procedure, where jurisdiction decides who gets their day in court. Thank you so much for watching. Be sure to subscribe, give us a like, and leave us a question or comment. If you'd like to learn more about what we do, check out lawschooltoolbox.com.